Good morning, everyone. Thank you for joining us. Welcome to the Law and Regulation for Robotics and AI Innovation webinar. I'll be giving a short introduction before handing over to our speakers, and we'll be wrapping up with a panel session at the end. So some quick housekeeping will just be, everyone will be on mute apart from whoever's speaking at the time. If you have any questions, please add them to the chat box. We have Poonam with us today who will be picking up any sort of technical related queries, and Yana and Caroline will be moderating the questions for the panel at the end. So it's just after 10 o'clock now. I'm going to run through my welcome. We'll have our speakers. They'll speak for about 15 to 20 minutes each. And as I said before, we'll be wrapping up with a panel discussion, and we'll finish at 12 at the latest. So many of you will be familiar with KTM. You've probably found out about this through one of our mailing lists or social media channels, but you may or may not have realised that we've recently rebranded. So this is our new fresh green branding and our mission statement of connecting people for positive change. So the mission is broadly the same, that we connect ideas, people and communities to drive innovation that changes lives. So this is an extract from our last annual report that gives you an idea of the reach that we have. So you can see there that we have almost 40,000 organisations in our network. So those will be businesses large and small, research organisations, not-for-profits and investors. So a really broad reach across organisations all over the UK in all sorts of disciplines. And we have historically held a lot of events. Obviously at the moment we're doing a lot online, and we have a really good attendance at our events as well. So a really good platform for sharing knowledge across different communities. So our community is focused on robotics and AI. So our focus is to connect innovators, end users and funders to accelerate ambitious robotics and AI ideas into solutions for real world problems. And so many of you will have worked with in the past, perhaps we've introduced you to an end user or a collaborator or an investor to help you bring your product to market. The sectors that we've focused on and continue to focus on largely are healthcare, agri-food, infrastructure, manufacturing, and at the moment we're scoping out opportunities in waste management as well. These aren't exclusive. We're happy to look at other sectors where robotics can have an impact and AI can have an impact, but these are just some of the major areas that we have focused on previously. So a lot of this activity comes under the banner of the Robotics and AI Innovation Network, which was previously called a special interest group. So it's the same group, just a different name. It's still the same principle of free membership. So you join by signing up to a newsletter. That's how you're notified of our events, opportunities, and online resources. And then if you participate in our events, that's the opportunity to network with other people from the network and from other sector networks as well. And the kind of overarching aim of the Innovation Network is to raise awareness of UK capability in robotics and AI technologies, and to accelerate the innovation in this field, and ultimately to increase the rate of adoption of these technologies. So one of the activities that we did earlier this year before lockdown, remember that, we had a vision day. So we got together some of our most active members, so people who'd spoken at our events or exhibited at our showcase, and kind of reviewed what was successful about the previous 2 years of what was then the Robotics and AI SIG. And we got some really great feedback about how the SIG had helped people, and we sort of said, well, we're continuing for another 2 years. What else would be really helpful? What else is it that we can do to help you to progress your robotics and AI innovations? And one of the topics that came out of the sessions was this topic that we're looking at today, which is law and regulation for innovations of robotics and AI. So that's what we've done today. We've brought together 3 experts who will talk to us about this topic, and you can all ask them your questions at the end. So just before I hand over, just to let you know how you can connect with us at KTN and the Robotics and AI team. We'll be sharing all the slides from today's session, so you'll be able to look back at this and use the links and reflect on the slides that you've seen today. But this is how you can get hold of us, and we love to hear from you. Drop us an email or follow us on Twitter, follow us on LinkedIn to see what we're up to. And yeah, look forward to speaking to some of you soon, and enjoy the session. So we'll start with, let me just hand over to our first speaker, and that's Mark Richardson.
So I'm a patent attorney at Kelty. I'm here to talk about patents and some issues that that may arise in the area of robotics and AI. That's me. So I'm in Kelty's IT, telecoms, electronics team. So we're generally split along scientific areas. So we have a chemistry bio team, we have an engineering team, and we have a team which is loosely sort of the software IT telecoms field. Within that we do have a special interest in AI and machine learning and the other things you can see there on the screen. Our clients range from start-out, spin-out companies all the way up to multinationals and anyone in between. So what I'm here for is to give you a very brief overview, 15 to 20 minutes, of intellectual property and specifically patents as it relates to this technology area. So what I'm going to do is a very whistle-stop tour through what different types of intellectual property there are, just so that everyone's sort of clear as to what I'm talking about. And then maybe just touch on some areas that crop up in conversation with ourselves when we meet people, sort of along the lines of, can I patent it? So a lot of people will say software innovation isn't patentable, so maybe touch on that, and some special issues that maybe is worth thinking about when you're looking at AI or robotics related innovation. So first off, intellectual property rights. There's a whole range of them, some of which you would have come across. They broadly split into two categories: those that you need to do something to get registration. So you actually have to take out an application form, fill it in, put something in with it to get it. And those that don't require registration, those ones that just come into creation automatically. So on the screen at the moment are IP rights that you need to do something, you need to register to get. So patents, which is what we were talking about, and patents will cover technical inventions, and they can be products, devices, methods of doing things. So there's a picture of an iPhone there. So the iPhone would have been covered or is covered with hundreds of different patents related to its screen, its antenna design, its chip design, the way that it actually works. Registered designs, essentially designs are protecting what you see is what you get. So there's a picture of a trunky child's luggage there. So the shape and look of that is protected by a registered design. Registered trademarks attached to branding related matters. And for anyone who's into trivia, that's the UK's first trademark. They're the Bass Triangle, Bass beer. That is quite old, but it is still in existence, still in force. And domain names also require you to register. Those that don't require registration, so will be copyright and an unregistered version of design right. And generally here we're talking about, as it says there, artistic creations, literary works, music, artwork, things like that. Common law trademarks, this is a sort of unregistered version of trademarks. So you can still get some protection even if you haven't registered a mark. And there's the two 118 runners there from the directory inquiries sphere. They weren't registered as a trademark. And then know-how and confidential information. So those are the broad types of intellectual property that we come across, but I'm going to focus on patents. So there's a huge subject area, but I'm going to cover just a few things that might be of relevance to this area. So there are three requirements really for an invention to be allowable. The first two will apply to pretty much any technology. The third one is more of an issue when you start talking about computer implemented inventions. mathematical methods. So the first one, novelty, just basically means has somebody published your invention before? So if you imagine a world where the table doesn't exist, there are no tables at all in the world. If you were the first person to invent a table, be it 2 legs, 4 legs, 6 legs, whatever, you would have novelty, you would be new, no one would have done it before. But if in this weird universe where there are no tables, somebody does actually have a 4-legged table out there, but you've come up with a 6-legged table, let's say, you would be new. You would be new still. You would have novelty because you're different. You've got 6 legs versus 4. But the question then moves on to whether what you've done is inventive or not. So is it inventive to add a couple of extra legs? And you'd probably say no, it's not. So this would be an obvious extension, and so you wouldn't be able to get a patent because of that. So those are the 2 basic requirements, novelty and inventive step. There is this third category, excluded subject matter, which crops up in the sort of software invention world. So what we're basically referring to here is that the patent law in the UK and Europe has a list of things that aren't regarded as inventions. And those things are listed on the screen there. The ones that are coloured in a sort of reddy purple are probably the ones that we come across a lot. So things that are classed as a business method, computer programs and mathematical methods. So you look at that list and your immediate reaction is, well, I can't get a patent for my software invention. But there is some weasel wording up the top in the title. The phrase in brackets as such is your sort of get out of jail card. So what the patent system is attempting to do is to stop you from protecting something that is a sort of pure mathematical method. So to take an example, there was a patent that was filed. It had an equation in it that described how light passed through a lens. And initially that was rejected as just being a mathematical method. It was just telling you how the light would be refracted as it passed through the lens. But then that was also linked into how to make spectacle lenses. And so that reduced your mathematical method into a real world device. And suddenly that something that wasn't patentable did become patentable. So what we tend to look at in these particular areas is whether the innovation is contributing something that's regarded as technical or something that's regarded as non-technical. And that's the big challenge a lot of the time. So things that are a scheme for running a pension scheme, that's a pure business method. A computer software program that controls the braking system of a car, that's doing something technical. Those are probably at 2 extremes, extreme examples, and there's a whole range and continuum of things in between. So some places those things will be regarded as technical and allowable, and in others they won't be. So there's quite a lot on this slide, but we'll run through it. So when we talk about protecting computer implemented or software inventions or mathematical methods, particularly in the UK and Europe, as I said, we look at this as such wording. So anything that's abstract is out, but things that have a tangible application are generally on surer ground. So the EPO is the European Patent Office, and they have granted patents for inventions in, as it says, image processing, user interfaces, AI, which we'll look at in a bit more detail, genetic algorithm, database systems. So all these things are essentially mathematical methods or software programs, but they are linked into something tangible, something that you can protect. So this is often the big challenge that we find when we are presented with a software invention is whether we can find a way of expressing it that brings out the technical contribution that it makes to the world at large. Within all of this, there's a question as to how AI machine learning inventions are treated, and the European Patent Office just treats them as any mathematical method. So they aren't treated in a special way. They'll be looked at in the same way as as any maths related innovation is. So again, you have to link it into something. So when we talk about innovation in this area, there are probably a few things to sort of bear in mind. So if you're looking at the robotics field, now this is quite a wide field. You may find that your invention can reside in a number of different categories. So I've got up there the control system, sensors, the actual mechanical system, or how you're using this device. And one of the things that it's important to do is to identify where your innovation is within all of that. And it may be more than one place. So it may be that you are protecting a piece of software, but you're also got a new method of use. It may be that you've got an enhanced sensor that is incorporated into a system, mechanical system in some way that's new. So you might have, your patent application might be directed towards different aspects of your device, and you may have more than one invention, or you may have more than one way of describing it. So for robotics in particular, and this is similar sort of considerations apply in sort of like the Internet of Things environment, is that it's such a broad field and that there are so many different aspects to it that it's important to identify what it is you want to protect. As far as AI and machine learning invention is concerned, this is a relatively new thing for the European Patent Office and the UK office to protect or to consider how they assess them. So it's sort of an evolving area, but there are some things that have sort of already crystallized in the way that we can see that they are treating things. The first is if you're talking about an AI invention as essentially being a piece of maths, it's very important that you don't use stuff that is just within your sphere, and so you're using terminology that you're familiar with, but others aren't. So the first thing to do is to make sure that what you're talking about would be clear to anybody that picks up a patent application that you filed to your invention. One of the deal, as it were, with a patent application and with a patent is that you're making a deal with the state, and in exchange for disclosing how you've done your invention, you can have a monopoly to protect that invention for up to 20 years. But part of that deal is that you have to disclose your invention in a sufficient detail that a third party, if given permission, could reproduce your invention without running into any roadblocks along the way. So if your patent application is littered with very specific terms that only mean something to you, then you're arguably not disclosing the invention in a sufficient detail such that somebody else can reproduce it. So that's one thing that's very important to consider, and make sure that you're using consistent terminology. The second thing on that list is stating a technical purpose in the application. So the claims, the reference to claims there is, in a patent application, they're structured in very similar ways. There'll be a bit of background that sets out what your invention is addressing. There'll be a very specific description, usually in conjunction with some figures, that shows you exactly how to do the invention. And then there are some statements at the end, the claims, that define the scope of your protection. So this is where the language drops out from being understandable into sort of legalese. But it's a section of the patent that gets a lot of attention because it's you don't want to claim something too narrowly so that somebody can design around you. You don't want to use terms, as I said, that aren't recognized. But something that is important especially within the AI field, is to actually state what the technical sort of purpose of your invention, what it is that you're doing. So if it's a method of analyzing the exposure that an individual has got from being within an X-ray machine and making sure that they're not overexposed before the X-ray's got what it needs to do in terms of clarity of the image, that could be a technical purpose that's described in the claim. And then all the features that you then have that support your claim should be directed towards that purpose. And that helps the Patent Office understand what it is you're claiming, and it also reduces the chances that they would argue that you're disclosing something that's abstract. The other thing, so I've touched on this sufficiency of disclosure. So this is where you're disclosing something sufficiently that somebody else can reproduce the invention, and it has to be clear, and it has to be a full disclosure. So you can't leave bits out. You can't leave the clever part. You can't leave the specifics of what you're doing vague. It has to be sufficient that somebody can reproduce it. And within the AI field, that can sometimes be difficult because an AI system may effectively operate as a black box. One of the risks that you would then have within your patent application is that you would be disclosing essentially a result, a desirable result to be achieved, rather than saying how you've done it. So this is referred to within the patent world as a free beer claim. So most people, well, me, I guess, the free beer would be a nice thing to have, but just saying I want free beer doesn't tell you how you're going to get it. It's a sort of desirable end result. And within the AI field, something similar. You can say we are setting our system up to be able to tell you when to turn off your X-ray machine. But if you haven't described exactly how that's done, the structure and the functionality of the system that supports that, then you will be probably found that you won't be sufficient. So there's a bit in brackets there right at the very end, because I was running out of space on this slide. It may be that sufficient disclosure in a patent application in the AI field means you need to disclose exactly how you set up your AI system. So the network arrangements, the weightings of different nodes. Or it may be that if you've got a patent application, you're saying this is 10% better than the previous way of analyzing an image and identifying a certain feature within that image. 10% improvement would be great, but unless you can actually demonstrate that that's the case to the patent examiner, it may look very similar to a prior system, and he may not appreciate, for example, if you've constrained the number of nodes within your network to a certain arrangement, he might say, well, that's just a choice. There's no real meaning to that. There's no real purpose to that. But if you've got some test data that backs it up sufficiently, so you can compare and contrast, then that would help you immensely. So I think I probably got to the end of my slides here. Yes, I have. So that's a very, very quick run through of some high level aspects about the patent system. I'm more than happy to take questions when we get to that stage. Anything to do with patent related protection. Just remember, of course, not to disclose anything specific about your invention. One of the aspects of the patent system is that you shouldn't disclose before you filed a patent application. So I have to put that little word of warning in there. But anything that you might want to ask about how you might go about it, whether it's worth doing, the interaction between different IP rights, anything like that, please feel free to drop it into the Q&A box for later. And I think that's the end of my presentation. So
thanks very much, Mark. So up next we have Doug. Doug, are you happy to take over?
Well, good morning, everyone. My name is Doug Bryden. I'm a partner at Travers Smith, based in London, and I'm a lawyer like Mark, but I specialize more in regulation and risk. Now, I particularly have a focus on health and safety type work, as well as product liability. So that's a bit of preventative counseling, advisory, and as well as when things go wrong. So kind of crisis response and regulatory defense. In this part of the talk, I'm going to carry on looking at legals. Mark's obviously just gone through kind of patents and protecting IP, which is genuinely fascinating in this area. We're going to move or shift gears slightly to consider more operational risks and issues. So this is probably more future looking in many regards, to see what the developers of these products, the users of these products and technologies are going to potentially face from a legal liability standpoint. We'll split it into two parts. We'll consider legal liabilities, which is going to be probably about 5-10 minutes, and then we'll look at legislative frameworks, and I'll introduce some of the policies which are coming out of Europe and elsewhere in this sector. And that will neatly then enable me to pass on to Seb, who will really go into the policy side in a bit more detail. But before I kick off in any of that, I think what I would like to do is just maybe put cards on the table here. If this industry takes off, as I think we all hope and think it will do, it will be a fascinating area to watch if you're on the outside. But if you're in it and you're developing these technologies or using or promoting these technologies in AI and machine learning, I think it's going to be very challenging and frustrating. The simple truth is the legislative frameworks as they currently stand, the regulations, the common law liabilities. And when we say common law liabilities, what we're meaning is that's the abilities of parties to sue each other. They're currently all based on kind of dumb products where you can quite easily find a human controller. So that ability to find blame is relatively straightforward as it stands at the moment. And what we're looking at here is just so not that. This is machines and technologies, robots, AI products, which will develop and learn themselves. So the short answer is I'll be giving you an overview and some of my kind of thoughts and observations about how the liability regime is going to have to develop. But we are really very much at the foothills of this proverbial mountain. So let me crack on. This is the main issue, and I think this slide will probably kind of demonstrate it fairly neatly. There are going to be so many different players involved in an AI type product or technology. Designers, manufacturers, programmers, deployers, data providers, and there might be multiple data providers through the life cycle. And then that's fairly straightforward. They're going to probably be individuals or entities very much in a normal supply chain who will be developing and promoting those steps. What then is the conundrum is that these systems and technologies are going to develop, they're going to learn, they're going to modify through their life cycle. And the AI system in itself is going to be taking systems. And I think when you're throwing in the AI system, that is the curveball, because that has no legal standing. It's not like you can blame the computer. You can't have recourse against the computer or the programming. So I think the number of different providers, the way the technology kind of works is where kind of the uncertainty is going to come in. So that autonomy, single biggest advantage or characteristic of these products and technologies, but that is going to be the legal conundrum. The question then is, something goes wrong, how do you allocate risk? I mean, in a normal scenario, a product or dumb product comes out of a factory, you do a root cause analysis, and that's where you find fault or defect is normally the legal term, and that is why something has happened and you can blame someone. But again, that point of if it comes from machine learning, how do you clearly identify that person when there is no clear human error? It's going to be an interesting one, and there are some kind of solutions being proposed by the EU in particular, and we'll get onto those shortly. But before we do so, let's just have a quick think about these types of risks and impacts. IP, I think, will be fascinating. We just heard from Mark about that. But also there's another question of when these systems are operating, how do you class the kind of the work created? Is it going to be owned by the kind of the AI, because it's probably not human operators who will be creating it? So that's an interesting one. But into my bailiwick, stuff I know about, let's talk about operational. I think the one which everyone will kind of jump to will be safety and personal injury. We can all imagine an autonomous car crashing. So yes, there will be more interplay with machinery which will work or co-work, cobots as they're sometimes called, with current or human employees. I think one thing which is clearly on everyone's kind of agenda is also mental fatigue and health issues. I think the level of stress that employees will be put under will be significant. I think we probably all feel that now, even with multimedia, Zoom calls. it's intrusive, and it probably means you have to operate at a more consistent, higher level than probably 10, 15 years ago. But other areas to think about will be privacy, data breaches, data gathering, well publicized. How much control will people have over an AI system which chooses to gather data? And then economic loss will be another kind of liability which may arise. AI systems will be used in investment decisions, logistics, routing. How will blame be allocated where one of those goes wrong? Product liability will not respond in those systems because they are designed more around a physical product as opposed to a technology or effectively a service being provided. And last but not least, I think another well-publicized area with AI is around discrimination and employer relations issues. It looks to be that a lot of these AI systems are discriminatory, both along racial or gender lines. I think, as always, you can't necessarily blame the machine. You can blame the programmers or the data sets which are getting put in. Fascinating issues. But I think you know, the real crux of it is that the current regimes will not be able to cope with all of these challenges which are going to get thrown at it. Let's just try and kind of illustrate that slightly. If you look at safety, which is probably the one which we can probably all conceptualize the easiest. Currently in the UK, as I said, if a product fails, a dumb product, let's call it, we find a defect, and then there will be a blame, and there'll be a quite clear liability regimes to put the victim or the consumer right. So you can claim under the regimes. There might be an enforcement action, and there might also be a common law or tortious rights, such as negligence, you can look at. And ultimately, between parties, there'll be a lot of contractual wording where you can get your legal recourse. Nearly all of these are based around concepts of duties being owed by one party to another. There being some form of foreseeability of a loss or damage arising if something goes wrong. And it's kind of what you would normally hear lawyers refer to as causative or fault-based regimes. Fine, it's been around for years, it's well developed, lawyers understand it, a lot of lay people, business people fully understand it as well, and it applies very easily to a dumb product or dumb technology. What comes out of the factory is pretty much what's going to be in play throughout the life cycle of that product. Trouble is, as I've said a few times already, when that product starts learning and acting on its own, who do you then blame? And that is kind of going back to where, how do you kind of work through foreseeability and a duty when actually the breach is done by something which is out of someone's control. The key question really then is, what happens when AI is deployed by a user and there's an injury? Who bears the liability for that? How do you allocate between those various parties? It just pulling all of this rambling together into a kind of an initial conclusion is the systems we currently have just do not cope with the complexity that kind of AI and robotics is going to throw at it. So there is a significant gap in the legislative framework as it currently stands. EU proposals are now coming forward, and we'll come on to that in a bit more detail shortly, but I think everyone is realizing that there is a gap that needs to be plugged. A number of ways this could happen. There could be this idea of a strict liability on deployers. So a deployer of what they're going to refer to as higher risk AI technologies, and we'll come on to higher risk shortly, they will have a strict liability. So in the kind of the easiest way to explain that is all that idea of duties and blame, take all that away. It is, if something goes wrong, the deployer will become liable. So that will be interesting if they go down that route. It seems likely that something along those lines is going to come. Now, to make that work, what we've seen in other industries, for automotive, for example, is you then kind of couple that with an insurance policy program. So there'll be mandated insurance that the developer will have to put in place. Now that in some ways seems very onerous, that everyone has to kind of take out an insurance policy to pay for it. But in a way, what you're doing is you're creating a pool of funds or financing. So when someone is injured by this, rather than there being a victim who cannot get recompense, the insurance will take over. Very similar to the car or automotive sector. Another approach might be joint and several liability. That's fairly aggressive and uncommon in most legal frameworks, but that would be effectively saying between all the parties I've listed on that slide, they will be joint and severally liable, and it doesn't really matter. A claimant could come across or go against any one of them, get kind of legal recompense, and then it would be for those parties to fight it out amongst themselves. I mean, all of this is going to be challenging and difficult, but I think necessary to give kind of the government and society confidence in these kind of technology developments to allow them to really kind of move forward. So in some ways, when I'm saying that, this is going to be onerous in the fact that you're going to put insurance programs in place, or there's going to be joint or strict liability, yes, it will be, but I think the financial benefits to the industry of having that playing field, which everyone is confident in going across, will far outstrip the costs of kind of actually putting those risk management measures in place. So fault-based liability, I think, will also probably remain for kind of lower tech AI robotics. I think what we're talking about here is what the EU is referring to as the high risk sectors. And I think the kind of classic manufacturer default, so we're talking about products, if it's nothing to do with the AI, but it's simply that a part of the product's defective and it's not to do with that remote learning or the kind of the wizardry bit, then I think the normal regimes will quite happily apply. So really, really fascinating on the AI side and the legal liabilities and how they might flow. I mean, just kind of pulling it together, and again, these slides will be shared and made available after the talk, so it is all summarized here. What we'll see is the duties of care, that's kind of what a company will owe to the others, remain largely the same for kind of manufacturers. I think it will be the operators. We should probably anticipate in the legislation some quite clear new duties will be put in place. Might be strict liability. Be interesting to see how that goes. I think the concept, really, if I was boiling it all down from the readings I've certainly seen and some of the discussions I've been in, is that what they'll do is they'll probably look at who has the most significant commercial benefit from the deployment of the operation of the AI system. And they're the ones where the new duties will probably come in. And that joint and several liability might well then come in just as a kind of a backup to sit around it. So look, that's a very whistle-stop tour of how these liabilities are going to arise. I think it really is going to require more legislation to make it all work, and case law will need to develop. So at the moment, the lawyers can give you an indication of how it's going to look, and I think it's sensible if you're looking to go into this world to kind of get an understanding of it. But any real rock-solid answers, we're just too early for that at the moment. But that is being plugged. So on the legislative developments, just quickly in the last few slides, EU has been interested in artificial intelligence now for the past decade. Back in about 2014, they started really investigating these issues and concluded that clear guidance and frameworks were going to be required for the regulation of robotics and AI and the related ethical issues which are going to come out of it as well. We put together a timeline here which shows that there's been a continuing focus on these developments, particularly in the last 2 years. Things have started to sped up. EU legislation is going to be very important. I mean, Brexit, unfortunately, is going to have an impact. I haven't heard the latest. I mean, anything which is developed from now on isn't automatically going to be pulled onto the UK statute book, but I think the UK will probably mirror or very closely mirror some of these developments. All this legislation is really pushing at is a number of key areas: transparency, consumer safety, cybersecurity, this whole issue about duty of care, and then allocation of liability. And then the really interesting aspect is this high risk AI and what classifies as that. And that would be the area of kind of greatest scrutiny. Excuse me. The UK, just to be clear, we don't have any real specific AI related legislation. We're just relying on our general consumer and product safety, health and safety regimes. But there are one or two examples of kind of movement. I mean, in 2018, the UK introduced the Automated and Electric Vehicle Act, and that clearly just said where there's the insurance in place, you go against the insurer. So it's kind of a clear indication of they want to make sure that people feel comfortable that they can have a right of recourse against someone, and in this case it was the insurers. But obviously everyone, the developers, will need to kind of pay into that insurance program. So look, quickly in the last few slides, high risk AI is a concept you're going to hear an awful lot about. This has been promoted by the EU Commission. It was in their recent 2020, I think it was earlier this year, March paper. It's a white paper. So what, and I'm sure Seb will go into a bit of the detail on this as well. The high risk framework made a distinction between kind of the higher risk, as they decide what that is quite interesting, and other AI systems. If you fall into that higher risk category, and that will be looking very much at the sectors. So is it healthcare, manufacturing, etc. And the purpose of the AI, if you do fall into that higher risk category, then you're going to be subject to more regulatory control. Really simplistic and good in some senses, but quite a blunt instrument and inflexible. I mean, the EU's proposing that there'll be a set list of what is going to be high risk and non-high risk. And they're going to go through a process of lobbying, I suspect, to make up those lists. Really been criticized by many. The Americans, for example, just think it's far too simplistic, and I do have a lot of sympathy with their kind of thoughts on that. It is such a broad church of robotics, AI. It covers such a variety of different applications and uses that it will be difficult. But effectively, look, if you want to know for now, and as I say on the slide, high risk will be where it's kind of likely to cause personal injury in a random and unpredictable way. So it's really where you cannot say for sure how the AI is going to develop and be deployed. And they'll look at the probability of occurrence, severity of the impact or harm, and lastly, the manner in which it's being used. But just to kind of reiterate, if you are in that higher risk category, you've got to realize that you are going to probably be subject to far greater kind of regulatory control, which will probably be around having to put in place the insurance, strict liability, and potentially shared liability as well. Last couple of slides and I'll hand the baton on. Possible scope of regulation, higher risk. I think we've talked a lot about a lot of this already. I know Seb will look into this as well. But one thing I just did find interesting is the bubble in the middle, where one thing that EU are wanting is that citizens be made clear when they are interacting with an AI system and not a human being. And I've got a little ditty at the end of my slot, which I'll just kind of talk through, which kind of illustrate that. But that really is that transparency on what's going on. So best practice, what would we recommend to people who are looking to develop AI technologies, get involved in this sector? I think it's going to be very important to kind of keep an eye on how it's going to be regulated. You've got to be all over the policy, understand how things are going to develop. You're going to have to work with people like Seb on being right at the kind of tungsten tip of that drill bit to work out what's happening next. Because I think if you do miss out on an opportunity, say, to kind of lobby to be non-high risk and you fall into a high risk category, that could give you massive developmental costs and kind of maybe potentially make your development uneconomic. Look at the case law as it develops, work out what your key jurisdictions are. There will be differences in this between the EU member states and globally. Work with the insurers market. Automotive industry goes, hand in glove of the insuring market to make sure that the products work. I would say to suggest the same in the AI world. And lastly, just take a step back and think of ethics. One thing we see in wider, more traditional product liability and business scenarios now is this focus on ethics and doing the right thing. So it's non-legal, it's more reputational, and you're kind of a social permit to operate is what some people refer to it as. I think sometimes this gets sneered at, particularly in the UK, funnily enough, by people just kind of, you know, maybe a certain type of person who thinks it's kind of a bit wishy-washy. I would say this is actually serious, and if you don't get that right, products are going to struggle to get off the ground. I'm Doug Bryden, been a pleasure speaking, happy to take questions at the end. The ditty I was going to make mention of is the one I put on that slide. As always, doing a little bit of kind of checking and research before speaking, I came across this, which is in The Guardian yesterday. Humans must keep doing what they do, hating and fighting each other. I will sit in the background and let them do their thing. This was an article, Google it, fascinating. It's from yesterday's paper in The Guardian. It's a 500 word essay where an AI system was asked to write a piece on why or how it would persuade humans not to be scared of it. Fascinating and chilling at the same time. But I think if you want a good example of how an IP content and who owns it is, this was generated, purported to be generated by the computer. Anyway, enough rambling from me. I hope that's been helpful, and I will now pass on.
Great, thanks very much, Doug. Really interesting and great to see so many questions in the chat box. Keep them coming. I think Jana and Caroline will have a job picking the best ones. So yeah, over to you, Seb, if you want to take control.
All right, thanks. So thanks very much, Doug and Mark, for really excellent presentations. So hi, my name is Sebastian, and today I'm going to talk a bit more about the broader AI policy and regulation ecosystem. So I'm kind of zooming out a little bit, and I'll be discussing some recent developments in the field. So before I do, a few words about myself. So I previously worked as a lawyer in international arbitration, but recently spent a year and a half with the Office for Artificial Intelligence, the UK's AI and strategy, AI strategy and policy unit. And I've been focusing a lot of my work on regulation, the public sector use of AI, and as well as a few kind of international initiatives. And so for this presentation, I'll be discussing, so first of all, kind of the broader AI policy ecosystem in the UK. So, you know, some comments on past and future trends. Then I'll skip to the EU's kind of general ambitions on AI regulation, and quickly discussing any recent developments over the last few months and what's likely next. And then finally, I'll be discussing AI ethics beyond regulation, and specifically I'll be talking about fairness, which I think is a potential risk that can't necessarily be addressed by regulation or legislation, but that companies should still bear in mind. So the AI policy ecosystem in the UK. So here's, so first of all, actually, I define AI policy and strategy as kind of being the analysis and practice of societal decision-making about and with AI. So it's kind of very broad on purpose, because automation and AI will affect many different parts of society, and kind of surfaces new and old questions that we need to kind of reconsider or consider from scratch. And the type of issues policymakers work on in this field are, how do you prepare and upskill regulators, for example? How do you remove barriers to adoption of AI in the public sector, and even in the private sector? Or, for example, how do you reduce the gap between demand and supply of AI talent? And so this is the kind of stuff I've been working with when I was at the Office for AI. And here you see a bit of a, you get a bit of an overview of the different types of institutions that are involved in policy making and regulation on AI. And this is, of course, non-exhaustive, but gives you, an idea of the types of, the key kind of institutions and departments. So, for example, you see the ICO there. They're a particularly proactive regulator in the field. They, in fact, a few weeks ago released guidance on how to interpret data protection law as it applies to AI systems. So for my part, I know the Office for AI a bit better. And so for, when I first joined, I think the focus was often on data, skills, adoption of AI, international relations, and leadership. And leadership being the creation of the AI Council, which I can discuss as well. But more recently, there's been a focus on obviously COVID, but also developing a national strategy, and also on kind of working with the Global Partnership on AI, which was launched a few months ago. Again, I'll be discussing this in a few slides. So this is broadly kind of the landscape, and a few thoughts now on kind of the last few years and where things are going. So from 2016 onwards, governments around the world have been very proactive in this space, and they've been releasing a number of strategies, white papers, consultations, and so on. I think Canada was actually the first government to release a strategy. And so that led to lots of new institutions like the Regulatory Horizons Council and the Centre for Data Ethics and Innovation in the UK. On the private sector side, there's been more and more kind of scrutiny from the third sector, and therefore we've seen more and more kind of open source tools trying to address certain risks, but also lots of principles. I think there's a few studies looking at these. There's a great one by Jessica Cousins-Newmans at Harvard. I think she identified something over 200 principle sets around the world. And so, principles can be useful, but they're also, sometimes criticized as being a bit ineffective and not particularly helpful to kind of data scientists, data engineers, and product managers on the ground. So, so this was, I guess from 2016 to 2019, this is what's kind of been broadly happening in policy, but things have kind of accelerated in 2020, or at least at late 2019. So this week, actually, there was a poll released by the British Computer Society, and it found that over half of UK adults have no faith in any organization to use algorithms when making judgments about them in issues ranging from education to welfare decisions. And we've also, I'm sure you've all heard about the A-levels debacle recently, as well as the kind of recent ruling that facial recognition used by the South Wales police was unlawful, or in that particular instance. And so there's a lot of focus now on kind of trust, on scrutiny, regulation, monitoring. And I think that's very important, and kind of governments are around Europe and to an extent in the UK are slowly starting to realize that, because if you want society to kind of adopt and use these tools, you need to, they need to trust them as well. And so this also led to the creation of the Global Partnership on AI. So that was initially an initiative between France and Canada. Then the UK subsequently joined, and a few months ago, so did the US and a host of other countries. And they recently launched 4 working groups. So one is responsible AI, the other is on data governance, the third is on the future of work, and the last one is on innovation and commercialization. But there's also a new subgroup focusing on the pandemic response. I encourage you to check out their website. They're kind of hosted by the OECD. And there are a few projects at the moment looking for partners. So definitely worth checking out. There's also NHSX that's been very active recently, as you can imagine. NHSX is kind of the AI-focused branch of NHS, and they've been looking to address the various barriers to development and deployment of AI systems in healthcare. And lastly, we've got number 10 and their interesting approach to AI and technology as a whole. So I'm sure if you've been following the news kind of this week, there's been some controversies with the withdrawal agreement. And I think at the moment, from what we can see here and there, number 10 seems to think that the UK should have discretion to invest without limits in high-tech, digital AI, and so on. And as a result, they're pushing against kind of state aid rules. I think that's not particularly helpful. We've seen I think that this is generally motivated by a fear of kind of tech giants existing in both the US and China, but the context is very different. And I'd argue that artificially subsidizing and creating a new tech company from scratch, or tech giants from scratch, will be ineffective and a waste of resources. Even in the past, we've seen the EU try this with Quora, which was their attempt to compete with Google, and obviously that didn't work out. Anyways, we'll see where this goes, but at the moment, there's a lot happening on AI policy, and I think in December this year, hopefully we should be finding out more about where money is being allocated through the spending review, and I think we'll have a better idea of where the UK stands on a lot of these questions. So now I'd like to quickly speak about AI regulation in the EU. And I'll give you a few updates on some of the stuff that's been happening over the last 2-3 months. So firstly, the EU Parliament launched a new AI committee. It started a couple of weeks ago, and the committee will try to study the impact and challenges of rolling out legislation on AI. There's so worth keeping an eye on that. And secondly, there's been also a new survey published on AI uptake by businesses in Europe. And so the survey kind of identifies a few barriers to adoption that we've seen quite frequently in the past. It's usually the same ones. The first one is difficulties in hiring staff with the right skills. Secondly, there's the cost of adoption, and then there's the cost of adapting operational processes. So it's a very interesting study and kind of also worth having a look at. Thirdly, and I think this will be of interest to many here, is the ALTAI, the kind of assessment list for trustworthy AI. And so that's a kind of a useful tool organized as an online survey of self-assessment questions. And basically any organization can go and try that out, and you end up getting a spider diagram which shows you the relative strengths and weaknesses of your AI system according to the 7 high-level principles that the high-level expert group has developed. So it's a useful tool. It has, obviously some flaws as well, but it, gives you a broad, approximate idea of, where you should, invest a few more efforts and resources to address risk. So fourthly, then we also have AI Watch, which released a first report on the use and impact of AI in public services in Europe. That's been of interest to me because when I was in government, I helped co-lead a review of the use of AI in the public sector. So we kind of identified something like 200 different potential use cases, a proof of concept, scaled applications, and so on, and looked quite closely at the barriers, the blockers, and so on. And what we found at the time is, 100% consistent with what AI Watch has found so far. And that is that, despite the hype, adoption remains quite low in government. And so far, there remains little evidence of social and economic impacts from the use of AI in public services. This is not because AI is ineffective or it's really hype or anything like that, but I think it's mostly because of various technical and social barriers. On the technical side, you have things like interoperability, different systems that don't communicate with each other within government. And on the social side, you have things like an unwillingness for sometimes to share data between government departments, or equally lack of knowledge or coordination problems. So that's an area also that will require a lot of investment over the next few years, and I would suspect that we'll hear a lot about that in December with the spending review, at least for the UK. And lastly, there's been an AI and civil liability study that's been published, I think this week or even the week before perhaps, but it's a very interesting study. I haven't read it in full. It's quite long and I've had a lot of work, but broadly, they, from what I've seen, they seem to kind of advise policymakers and legislators to avoid technology-neutral regulatory regimes. So that means they're going to be increasingly looking at, AI specifically or crypto specifically, and even for AI, they seem to think that AI-based solutions should be clustered in sufficiently uniform classes of applications. So they're, identifying technologies presenting similar technical traits, and as well as corresponding to different legal, social, and economic concerns. So it's, it gives us an idea of how they're thinking about regulating AI. And I think it's a helpful step forward because some of the critiques of the white papers they've published in the past were that the EU kind of tried to look at regulating AI as a whole, but there are so many different types of AI applications, use cases, and methods and techniques that a single kind of horizontal standard would be very difficult to apply consistently and effectively. So these are some kind of recent updates, and Doug also helpfully mentioned the white papers. So there's been 4, one on AI, liability, data, and one on kind of general vision the EU has. And I think last month we've received a lot of responses to the consultations. So you can actually download these on the EU's website, and there's a summary of kind of the different types of responses by actors. So in total, I think there were 1,215 responses. The majority were from citizens, then from businesses, and a lot from civil society and academia as well. And I think overall, at least for the white paper on AI, I think respondents kind of agreed with the EC's concerns and the risk identified. And there was some cautious support from proposals tackling them. Generally, I think there's a lot of support for measures tackling bias, privacy, and risk to human rights. But the issue is that it's often very unclear how to do that exactly. So, and if you look into results, 33% of the respondents thought that current legislation needed to be modified to address these gaps. 42% thought that a new regulatory framework should be created from scratch to regulate AI. And only 3% of respondents thought that the status quo was sufficient. And so, there's a desire for something to be done in this space, but the what is a bit more unclear. So, Doug mentioned the high risk, low risk framework. And while many in the survey or in the consultation supported the high risk definition or framework, only 30% of respondents answered that question. So that gives you an idea of how kind of industry is also kind of approaching this. And the message generally seems to be, the right problems and risks are identified, but the specific regulatory proposals are perhaps inadequate at this stage. So there's still a lot of thinking that's going on in the EU, and a lot of work they need to do on that front. And at the moment, they also published a proposal for a legal act, and that's this essentially gives you 5 different options of what they'll be doing. So option 0, call it 0 because I think it's highly unlikely. That would be no policy change, nothing changes at all. That's very unlikely. Von der Leyen, when she came to power, said that she would regulate AI within the first 100 days of her mandate. Obviously, that didn't happen, but the desire is still here. Option 1 is EU soft law, self-regulatory measures. Option 2 is having a voluntary labeling scheme, which I think a lot of people have been kind of discussing and exploring in various fora. Option 3 is having mandatory requirements for certain types of AI applications. And option 4 is a combination of all the above. It's difficult to predict the direction of travel, but I would say it's probably going to be option 4 or perhaps option 3, but certainly a mixture of these. On the one hand, there's been lots of reticence from industry saying that the EU's plans would stifle innovation. You also had the kind of American Chamber of Commerce saying that some of the measures on data were sometimes a bit protectionist. And so there's a lot of criticism for the EU plan, but also a lot of support from academia and third sector. So ultimately, the EU will have to find something in between. And I think they'll have to look at certain kind of specific AI applications and use cases, for example, facial recognition. And I think before the white paper was released, many people thought that there would be a ban or a moratorium on facial recognition use. That's then been abandoned, or at least wasn't included in the white papers. But according to Politico and their kind of AI reporting this week, there's a chance of that coming back on the negotiation table. So we'll see what happens, but I think there's likely going to be a mix of mandatory requirements for specific categories like facial recognition systems and potentially some voluntary labeling mechanisms, but again, haven't seen that being developed so far. And how soon? Pretty soon. And I think, within the next few months, we'll probably have a more in-depth analysis of the consultation results. There's been lots and lots of kind of, appendices to the responses, and so the EU, needs some time to kind of review all this and give out a full-on, analysis of the responses. Although, as I mentioned earlier, you can find a summary of these. And I think the desire is that by March 2021, new legislation and regulations will be proposed, potentially even earlier. So that's not, it's still going to take a while for these to be kind of put into law. I think for GDPR it took something like 9 years. But things are moving quite fast on that front. So stay tuned. And last, I'd like to very quickly discuss AI ethics beyond regulation. So there are a lot of different risk and ethical issues and concerns when you're deploying and developing AI. And some of these potentially can be addressed by standards or some regulation. And there are also certain components that will be very difficult to regulate or to kind of to legislate. And here I'd like to talk specifically about the concept of fairness. And I'll be discussing the COMPAS algorithm. So I'm sure many of you have heard this many, many times. But for those who don't, now I'll give you a very quick introduction on what the COMPAS system is and how that relates to fairness. So AI is essentially statistics mixed with computer science. And in statistics, you make inferences, you make predictions, and as part of that, you can get false positives and false negatives. Your algorithms are rarely 100% accurate. And so this obviously has repercussions on humans when you scale these use cases in real life. And this is not something that, programmers would have to think about with traditional software. But now that you're using lots of, statistics, data, and making these kind of predictions, you have to also consider different mathematical definitions of fairness, a lot of which are not necessarily compatible. So COMPAS. COMPAS was an algorithm used in the US, and it outputted a risk score that indicated how likely a convict would reoffend if it was released. And so based on the score between 1 and 10, a judge would know whether to release someone on bail or not. And in 2016, ProPublica analyzed the COMPAS scores that were produced by Northpoint, which is a company that commercialized COMPAS. And COMPAS, and ProPublica deemed the algorithm to be highly unfair to people from minority backgrounds. And so in response to that, Northpoint said that this wasn't true. Compass was approximately fair in calibration for both whites and blacks. You know, if the score meant essentially the same, whether you're black or white, if you get a 6, you don't get bail, and if you get a 4, you get bail, regardless of race. So essentially it was colorblind. And ProPublica replied and said that, yeah, sure, that's fine, but our point is that amongst defendants who ultimately did not reoffend, blacks were more than twice as likely as whites to be classified as medium or high risk. And so this is basically, you know, a metric of false positives. So if you're black and you're innocent, you're far more likely to still be kept in jail than if you're white. And so this was ProPublica's criticism of the algorithm. They argued that a fair algorithm couldn't make these serious errors more frequently for one race group than for another. And the difficulty here is that, well, you've got different conceptions and definitions of fairness, and they're not actually mathematically compatible. So if you take ProPublica's point, what you could potentially do is try to rebalance the false negatives and the false positives. And by doing so, you could then ensure that people who, you know, the false positive rates are essentially the same for kind of both groups. But by doing this, you're essentially changing thresholds and standards for different groups. And this would mean assigning whites with, you know, higher risk scores than equally risky black defendants to mitigate the criticism that ProPublica brought forward. And doing so may or may not be positive and necessary, but that would also potentially be a violation of, you know, a tenet of equal treatment. And so in a way, you essentially have kind of the affirmative action debate now, but in a policing and algorithmic context. And the answer to this isn't clear. There's no, you know, right or wrong of this version of fairness is, you know, is better, or this, you know, it really depends on a lot of different considerations, including your political and ideological views. And so it's very, very tricky because you can't do both, as in you can't satisfy both definitions at the same time, given the data and given the algorithm and how kind of how statistics work. So how do you, you know, what can you do then? Well, I think first of all, this is also, you know, similarly to the A-levels scandal, this is an example of something that policymakers need to think about then. You know, should you actually use an algorithm in this case at all? And if you don't, is it actually fair to rely on humans who are also equally biased, or perhaps even sometimes more biased? You know, and one way around this, in this particular instance, is maybe even ending bail requirements and using electronic monitoring instead more widely. So a lot of different policy questions, but, you know, if you're a company developing these algorithms, these are kind of things you need to think about. And these types of questions exist in a lot of other contexts, you know, the mixture of bias and fairness. And I think ultimately what's important is that, you know, you need to be quite transparent about how you take these decisions, which kind of definitions of fairness you use. And it's important kind of for companies to engage with kind of experts and to really kind of acknowledge these trade-offs. And so, you know, how you do that is complicated and probably requires organizational changes. And you know, you have like certain tools that data scientists can use, like model cards, that, you know, acknowledge limitations and you know, explore these types of questions a bit more. But yeah, broadly, this is kind of just, you know, an example, I think, of things companies need to consider, and I think legislation or regulation alone won't be able to address. And that's it for me. Thanks very much.
That was great. Thank you, Seb. Really, really interesting talks there. And if I could ask all three of our panelists to switch your cameras on, please, so we can see you. And then I'm going to hand over to Jana to host the Q&A.
Right, so let's start with the Q&A, and also my very first question, I will not address it to a speaker in particular, and whoever wants to answer the question, feel free to unmute yourself. So we start off with a GCSE and A-level question, and the question is here, who in that case would be liable? Would it be the civil servant who recommended the software? Would it be the developer, or would it be the minister who in the end like went through it to use it?
I'm happy to answer that. So firstly, I think it's debatable to what extent the algorithm itself incorporates any AI. I don't think there's any machine learning involved as far as I know, and there's certainly no self-learning component, but that's irrelevant because at the end of the day, it's an automated decision-making process. So whether you're using AI or not, there needs to be you know, ways to kind of have accountability measures in place. And in this particular case, I don't think there's a particularly complicated question here. You know, if instead of relying on the algorithm, government simply flipped a coin to decide who would get their exams or not, you know, the answer would be the same kind of for both. And I personally would say that in this case, it's for ministers to be ultimately held responsible, because they ultimately have the executive decision-making power, they make that choice, and they also have democratic responsibility. And so in my view, it's really ministers who should be held accountable in this particular instance. And more broadly, I think there's also needs for having better processes in government for you know, data and AI kind of governance, and you know, ensuring that these things are developed and deployed well and responsibly. And I think that's not actually the case for now.
Yeah.
Excellent. Anyone else want to add to it?
Yeah, I maybe just pick up on the word liability or accountability. I think this is a situation for accountability, that a decision was made which was probably not as well thought through in absolutely extraordinary circumstances. And I'm sure if the other systems had been deployed which were on the table, of there would have been equal injustice, just other people feeling it. I think to maybe couch that as a liability and a legal liability is probably a stretch. I think it's more of a judicial review and accountability.
Yeah, agreed.
Excellent. So I hope that answered also the question from the person who asked. So coming to the next question. I think Doug used the word defect in his presentation. I'm not entirely sure anymore. But the question is here, how would you define a defect? With regards to liability of the manufacturer.
Yeah, no, defect's interesting. There's a lot of case law around what a defect is, and there's probably two ways of looking at it. I think there's a quality issue, which is where you have a product which doesn't meet its specification, and there's a quality issue. A defect is probably where it is unreasonably dangerous for a given use, or unfit for an intended purpose, is generally how someone would say a product is defective. And it could be a very small component within a product which makes it such. But yeah, it's where I think in this case, a defective product would be where you can't use it reasonably for its intended use.
Excellent. And the next question is with regard to Brexit, I suppose. So assuming that the EU regulates, how do you anticipate the UK legislature will respond post-January to it?
Happy to take that one. So I think, first of all, making predictions about the UK's government's actions is getting increasingly more difficult. But my impression is that the UK is not going to be, well, is not going to be a huge fan of the EU's approach to AI regulation. And I think a good indication, well, when I was in government, the idea was that, you know, rather than creating a new regulator, the focus should be on upskilling and funding existing regulators to better understand the risk posed by AI in their respective sectors. And I think that's a good approach. But on regulating AI systems more generally and kind of any legislation around that, I'm not sure there's a lot of desire at the moment to do any of that. And or potentially with specific use case, I think Lord Clement Jones put forward a bill for facial recognition technologies being regulated a few months ago as well. But so I think for the EU's plans particularly, I don't think there's going to be a lot of buy-in from you know, number 10. I'm not sure about how Parliament will be kind of deciding that, but I think a good piece to have a read is I think it was published a year ago in City AM by Mark Warner, who's one of the special advisors, I think, to Boris Johnson, and gives you a good idea of how, you know, I think number 10 looks at the question of regulation of AI. I think it's probably going to be something between what the US is doing, i.e. not much, and the EU.
Yeah, I agree with everything said there. Look, there's one reality about this, that anything which is developed in the UK will not be sold solely in the UK, and you then have to place it onto the EU market. And to do that market entrance, you need to comply with the EU product regulations. So I think there is obviously talk around, this is a great hope that we can move ahead in a slightly less regulated sector and kind of probably develop quicker. But reality is we're going to be selling into that European market, and we're going to have to comply with the European laws if we want to do that. And that's just reality here and across all of the product regulation world. So Yeah, I think people who think we're going to be in a Wild West UK and be able to promote are sorely misguided, in my opinion.
Yeah, no, I agree with that. I think it's yeah, the biggest trading partner will just have to abide to whatever kind of, and I think it'll ultimately also kind of depend on what the EU kind of decides to legislate on. I think there's been criticism of some of the kind of measures being a bit protectionist or a bit but whatever in the end EU goes for, I think yeah, the UK will have to kind of follow, or at least be if they want to sell their products in the EU as well.
Excellent. So the next question is regarding patents. How does it work if someone develops basically an automatic mathematical technique for verification of other software? Would that need, or could that be patentable?
Potentially. We have had inventions go through that have been sort of verifying whether code is free of errors or not, and that has been protected. One thing to bear in mind about the patent system is it's territorial. So different countries will have different approaches to things. The UK and Europe generally align with one another. The law in the UK mirrors that in Europe. But places like the US or South Korea are generally much more open to software-related innovation than the UK and Europe are. So even if your invention isn't protectable, maybe in the UK or Europe, it could be elsewhere. And if your major market is elsewhere, then that might just be as good as getting protection in the UK and Europe. But potentially, yes. I think one thing that we always do when we get faced with a new invention is to try and really get into what it's doing, how it's working, and sometimes you might find that the sort of the elevator pitch of the idea isn't protectable in Europe, but there might be an element within it somewhere. If you sort of peel back what's going on and you actually find the sort of architectural side of what's going on, there might be some potentially quite small element that is doing something technical. But if you can protect that, it's as good as protecting the overall invention. So there's no one answer to that. So if you are innovating in that area and you are interested in potentially filing an application, my suggestion would be to find a patent attorney. And most of us offer initial consultations free of charge, and you can at least run through what the idea is and get a feel for whether it's patent eligible or not.
Excellent, thank you. The next question is regarding regulation and legislation. And the question is there any opportunity for the UK to drive increased adoption and innovation of AI and robotics through forward-facing legislation to enable safe deployment of systems? Yeah, probably for Doug.
Yeah, I think there obviously is. I think actually the industry is probably wanting good regulation. Good regulation is so helpful. If it's done in the right way, it gives confidence to consumers, confidence to businesses, confidence to everyone to invest and use it. So I think the UK does have a real opportunity. I think if the question was driving at the UK as opposed to breaking free of the EU, I think it does come back, unfortunately, to we need to be very mindful in the UK of what's happening in the world, in the US, Asia, and in the EU, and to ensure that whatever we do develop is kind of incorporating those standards or those levels of regulation, because there is no point us having a fairly low level of regulation when to kind of commercialize, you're going to have two separate supply chains, etc. So of course we can, and I think the industry would probably very much like good regulation. I'm sure Seb would agree with that.
Okay. Seb, do you want to say anything about that, or any other opinion?
I actually didn't hear the end of the answer, so I'm not sure what am I agreeing with.
That good regulation would be helpful for everyone. But
yeah, absolutely. Yeah, no, I think that's key, because you can't just have a Wild West, and you'll need to kind of incentivize proper behavior and accountability, and you'll make sure that people are comfortable kind of using these systems, having these systems make decisions about them. If you have, for example, a facial recognition system, you need to be able to understand, where can these be used legitimately, where can't they be used, what rights of recourse do you have, and so on and so forth. And at the moment, none of that exists, or at least very little.
Excellent. So the next question is for the entire panel to discuss this. And the question is, yeah, are there any observations on know-how, IP rights, and how this relates to AI systems? Yeah.
I could start off on that. So I touched on know-how in my presentation. So know-how or sort of trade secrets would be the flip side, I guess, to the patent system. It's certainly true that not everything that could be patented maybe should be. There may be business reasons why you might not want to do it. But in terms of know-how, I guess the main thing that I would flag up is if you're not going down the patent route and you're relying on confidentiality to protect you, generally speaking, once the information gets out at some point either by accident or design, then you can't then cycle back around and try and protect it. So it's a perfectly valid choice to keep something protected as a trade secret as opposed to filing a patent application. But it's certainly, I think in each case, you should probably go through a process of assessing whether you want to do that or which option you want to go with.
Anyone else? Otherwise, I jump to the next question, which is, obviously, as we touched earlier upon, is that these machines and AIs become more and more complex, different layers, different suppliers, and integrated at different levels of a system. So who will have the ultimate responsibility?
I'm happy to have some observations on that. I think that is unfortunately the key conundrum. There are so many different people involved, and there will be a certain amount of machine learning at the end. I think reality is there's still going to be an awful lot of humans or corporations involved along that supply chain, and I don't think we at this early stage get too kind of fixated on these machines acting completely autonomously or independently. I think that's probably years away, but the problem is the regime doesn't allocate the liability as you would hope. And I think that's why the white paper and all the kind of discussions at the moment are trying to get a way through that. So a joint and several liability, they're all equally liable. So that would make sense. Or you would look to see who would have the biggest commercial gain from the operation of that AI. It's certainly the other way that they're approaching it. But I don't think there's an easy answer to that, and I think legislation will be required to pinpoint or to push allocation of such liabilities, because at the moment it really won't work. I'll stop there. Seb might well have some thoughts.
Yeah, I mean, I think that's right, and generally, I mean, even kind of other industries and non-AI industries, you have lots of different players in the supply chain that kind of participate in the production of a particular solution or product, and sometimes it's not that dissimilar. I think as things get more complex, you probably get some more interesting questions on liability, but to an extent, as Doug said, regulation and law could potentially address some of these things, but equally, I think there's going to have to be some agreements and assurances given between companies in the supply chain potentially. So, if you're the chipset designer, if you're providing the data sets, and if you're out building the algorithm, if these are three different companies, they'll have to have agreements between each other, knowing what are the assurances the data provider can give to the algorithm builder, or what can these two companies give as an assurance to the ultimate deployer. So to an extent, that will also probably be determined contractually, but there will definitely be cases where liability is kind of disputed and unclear, and further kind of clarification on that would be helpful. So I think, yeah, that's probably how I see it.
I think the difficulty here is, as opposed to a traditional product, is that the product or the technology will change through the life cycle potentially. So, I don't know, let's say it's a medical device, a pacemaker leaves the factory. It'll be the same pacemaker in 5 years' time when it's in someone's body doing its function. Here, the technology or the robot or whatever it is leaves the factory. It might well change in that time. And I think that's why it's going to be more difficult to find root cause analysis of what went wrong.
Yeah, absolutely. And I think in these instances, I think that's why it potentially be important to have certain requirements on keeping documentation and kind of allowing potentially the auditing of AI systems by third parties. And that might help sometimes kind of clarify. But it's a very difficult kind of space. There's a lot of research going on how to devise a proper auditing framework. I think the ICO actually suggested one. But the difficulty is often the same with AI, is that it's very difficult finding requirements, standards for AI as a whole, given that an algorithm recognizing your face on a phone will be completely different from an algorithm detecting cancer, and so I think you might need we need to be a kind of more sectoral or vertical approach to this eventually.
Excellent. So the next question is a patent question again. I will rephrase it slightly. So the question is essentially, why should I bother for my AI system to be patented? Yeah, because I have to give full disclosure, obviously. So am I not better off if I don't file a patent and use all the tech for my business?
That's a good question. In some cases, yes, it may be that it might be better to keep things secret. I sort of did touch upon in the know-how answer that if you don't file a patent application and the information comes out, then it's generally too late to then file a patent application and get protection. So it's certainly a decision to look into. The patent system doesn't immediately disclose what the contents of your application are. There is a lag of 18 months from filing before the general public will find out exactly what's in the application. So it's not something that will come out immediately, but it's certainly something that you can think of. It may also be that you may not need to disclose everything. I mean, the comments that I made in the presentation were very much for in certain types of AI system where you're claiming a better AI system, let's say, rather than the application of AI to achieve something. And when you're actually looking at the system itself, it may be that you need to disclose more information there to sort of get the point of the invention across. And at some point, you may find that you're running into a position where you're feeling uncomfortable, I suppose, about disclosing that much proprietary information. The other thing to sort of factor into all of this is, so some people will say, I'm never going to sue anybody under my patent, so why should I file for an application? Patents ending up in court is quite rare, and the bigger benefit and utility of a patent really is in the value that it can add to the company. So there's a figure that's bandied around quite a lot that these days maybe up to 80% of a company's value is in its intellectual assets, of which patents will be part of that. So protecting that properly will be quite important when you come to scenarios like selling a company. You can license IP in the same way that you can a normal piece of property. So you can derive value from a patent application in that way. And it may also be something that investors want to see, that you've investigated whether you can protect this system to stop other people from taking advantage of your IP. Even if they come up with it independently later on, a patent would still prevent somebody from fully operating in that way. So there's a number of factors to consider, and as I said before, I think the main thing is to have a process of sitting down and really thinking about whether it's appropriate in each case. In some cases it will be, some it won't, but it's best just to talk that through both on the business side and on the legal side.
Excellent. The next question is, yeah, AI and machine learning obviously rely on big data, and how is it possible for SMEs in the UK, yeah, to be able to afford to develop new products for global markets without affecting the IPR and EU regulations?
Well, I mean, I can't really comment on the kind of the IP legislation or aspects, but I think more generally there's this kind of difficulty with having all these kind of requirements, regulations, ex ante, ex post, certification system and so on when you're kind of a small SME with not a lot of money. And you have, you had this issue in the past with GDPR, and you have it again now with AI, and that's one of the key, problems for the EU is how do you ensure the safe development of AI without necessarily kind of hindering innovation and kind of activity with SMEs, because otherwise, obviously Facebook, Google, and Microsoft can afford armies of lawyers, but but that's not going to be the case for smaller companies, and so that's why it's important to kind of ensure that any regulatory framework, whether in the UK or in Europe as a whole, is adequately kind of designed to really kind of cater for like high risk applications and applications that kind of potentially learn over time and affect a lot of people. You have to have certain kind of criteria, but that's a very difficult thing to do, particularly in a field like AI, machine learning, where kind of data science usually isn't well regulated. And I think that's the thing. Regulating AI means the same as regulating statistics almost. It's very difficult doing that kind of effectively, and so there is definitely a risk for SMEs, I would say.
Excellent. The next question is then, there are standards under development for ethics of autonomous systems and AI. Do you know how these will relate to liability if they are advisory but not adhered to?
Yeah, look, quickly on standards. Standards, just to be clear, are not laws. So a non-compliance with a standard in itself is not necessarily a breach of law. The two ways standards gets used, I think, first of all, from a compliance point of view, just taking different types of products. So let's take medical devices or construction products as they are. There is a weight of EU legislation which has been flowed down into various jurisdictions, UK included, that to put those products on the market, they need to comply. And the way they demonstrate that is through what you might see as a CE marking. And that is demonstrating kind of product compliance. Now, if you adhere to the correct standard, you have a presumption of compliance. So standards are really useful in building confidence and demonstrating compliance. And I think we can probably see something being used similarly here, that when certain categories of product, probably not the whole lot, maybe higher risk ones, are being placed in the market, it wouldn't be unforeseeable that certain standards developed by ISO or others will be used as these evidential markers. So that's the first way they're used, and we can see that being deployed here. It's a way that industry can kind of discharge its duties and say, well, I've complied with that standard and that's acknowledged as being adequate. When it comes to liability more generally, I think if you're in the kind of the world of compliance or meeting a standard, it's very helpful, because if you're in the court of law and you're being prosecuted or you're being claimed against by an individual, and it goes back to some of those foreseeability points or some of those arguments, it's like you've done everything you reasonably can. So good standards, adherence to them will allow you to place stuff on the market, we anticipate, will also assist in kind of maybe defending yourself, but it will not be a complete defense. There's no kind of safe harbor legislation in the UK. So this would be an evidential kind of brick in the wall, as you like, but it's certainly not a complete wall. And it will not escape the really big risk around all of this, which would be reputation and commerciality. If you have incidents, but like the A-level fiasco, there might not be legal liability, but there'll be accountability, and for commercial organizations that will be reputational. So standards will be helpful. They're being developed, but unless Seb's got an inside track, I think they're still in that developmental phase.
Yeah, no, there's a lot of work going on at ISO and IEEE and kind of other standard setting institutions, but it's and including the ITU, but there's I'm not aware of any kind of recent progress on that front. And I think generally there's a lot of different initiatives happening, things like I mentioned third-party auditing, but sort of people are looking at certification of AI systems and potentially also having requirements on governance and process. If you can't micro regulate every single thing with AI, well, perhaps you have requirements on fiduciary duties, or not necessarily fiduciary duties, but essentially kind of requirements on how you govern these systems, and people in organization that ultimately have to be responsible for checking these and monitoring and human involvement and so on. But But on standards specifically, I'm not too sure where things are at the moment. Although I do think it'll take some time, because a lot of these questions also end up having, you know, socio-political elements to them. So, you know, how do you deal with facial recognition? Where is that, you know, within the standard, you have to think about things like bias and fairness, and potentially, and that could cause some disagreements between different countries looking at deploying these technologies.
All right, let's do like one or two more questions. One question is, what have we learned from the Boeing 737 MAX accidents and the fact these accidents were caused by a system for the good of people, and yet we haven't seen like a solution for this as of yet?
Trying to understand what's meant by accidents being caused by, you know, by a system for the good of the people.
Yeah, I have no idea why there were the accidents, because I thought that are the ones with the lithium battery, but I'm not entirely sure. So how AI was involved in there. So maybe we skip that one, which results in the last question, which is kind of a mouthful, so I will read it out. If a defect results in failure in intended use, there remains an issue with AI. Most developers will say that they don't have a specification for the behavior of the AI. The behavior emerges from the use of the algorithm. So how can we define an AI application as being defective if we don't have a recognizable, reliable specification for its behavior?
Great question. I think that really just kind of circles back to the current concepts around product defect, and the allocation of liability just don't work. I think that just sums it up nicely. It is that is an illustration of why there needs to be a plugging of that gap, that the use of the algorithm, if there's no specification or if it develops or changes, and that's probably where you then need to get to these new duties, which will take all that defect thing away. The accident happens, the problem goes, where the duty of cares will be established in a slightly different way. And it could be a strict liability, because you can't really clearly delineate between the parties where the fault lies, if indeed there is a fault. I mean, the A-level debacle, you know, is there a fault in the development of the AI and its application? Probably not. The fault, if anything, was probably more the decision to take that route.
Yeah, absolutely. I think that kind of, you know, there's it also in the end depends, you know, what kind of fault exactly are we talking about, and it could be, you know, a technical one. It could be one, you know, where you identify the cause being potentially the you know, the data set itself, but equally on, you know, how it's being used, and you know, you have these for example algorithms that people can ultimately just end up relying on entirely without kind of judgment or without any scrutiny. And I think sometimes that's, you know, also kind of human issues. The algorithms are imperfect. You need to understand how you work with these and the outputs, and you know, over reliance on what, you know, whatever computer says can also sometimes lead to, you know, to problems and faults which aren't necessarily, you know, technical kind of issues here.
But taking another example, if we said on this kind of what the kind of scenario we just talked about, if we're talking about an investment, so we all put our money with, I don't know, a bank, and that bank invests that money for us, and we have been told that it'll make various investment decisions which will promote the money, but it's actually used in AI technology which goes haywire. I think it'll be quite clearly, it will come back to that concept of who has benefited the most from the use of that AI, and arguably it would be the bank. So would you then, I think for us as the victim, or, you know, the consumer, we would simply go against the bank, and it would be then for the bank to then look internally and up the supply chain for its products. So, you know, some of it's quite straightforward in that sense. It's no different to really a poor decision, a poor employment decision, but it will be how far can you go up, kind of trying to blame others, and in some ways that's no different to how it is at the moment. It's just that this makes it more complicated, and without transparency and what Sebastian was referring to around kind of the data collection and gathering, it'll be very difficult for lawyers to actually, and others, to really unpick the blame game, because it's not quite as easy as physical products, which can be, it's just a simpler world where we're talking about algorithms and data sets. It's far more difficult to evidentially check through.
Excellent. Thank you very much. I don't think we have time for any more questions, so I will now hand over to my colleague Caroline to close the event.
Thank you so much for the three speakers. We really learned quite a lot from this particular event, and I am sure there is a lot of issues which we need to consider in future, because I think robotics and AI is going to be used more heavily now after the pandemic. So I think all these lessons needs to be included when we are developing and when we are using robotics and AI. Thank you so much, and we appreciate your time and answering questions. There's more questions here. Maybe we might post them to you, or these participants might contact you to understand more about what they want to know. Thank you all the participants for coming to listen to this. I think I'm sure you found it very, very useful, and thank you for all those KTN staff who have prepared this event. Thank you so much, and we are now closing this event. Thank you.